A courtroom packed with reporters, a defense strategy months in the making, and then, gone. Just 24 hours after signaling they would argue that their client was suffering from an extreme emotional disturbance, attorneys for Luigi Mangione abruptly withdrew the defense. No explanation, no public statement, no warning. This sudden reversal has left legal experts, prosecutors, and observers asking the same question. What happened overnight? Was it a strategic retreat? Did new evidence emerge? Did an expert witness back out? Or did the man at the center of one of America's most closely watched murder cases change his mind? Today, we open the shadow case files to examine the mysterious legal twist in the prosecution of Luigi Mangione, the man accused of the killing of United Healthcare CEO Brian Thompson, and the defense that appeared only to disappear. December 2024, New York City. Business leaders and investors gather for what was expected to be another routine corporate conference. Among those attending was Brian Thompson, the CEO of United Healthcare. According to prosecutors, Thompson was walking toward a Midtown Manhattan hotel where his company was hosting its annual investors conference when tragedy struck. The shooting immediately sent shockwaves across the nation, not only because of who the victim was, but because of the intense public attention that followed. News outlets covered every development. The investigators launched a highly publicized manhunt, and before long, prosecutors identified a suspect, Luigi Mangione. Mangione would later plead not guilty to state murder and weapons charges. He has also pleaded not guilty to federal stalking charges connected to the case. As investigators continued building their case, prosecutors argued they possessed evidence linking Mangione to the crime scene and potentially shedding light on the motive. A key court ruling in 2026 allowed prosecutors to present much of that evidence at trial. For many legal analysts, the case appeared increasingly difficult for the defense, which is why what happened next surprised nearly everyone. As the September state murder trial approached, defense attorneys appeared ready to pursue a strategy that could dramatically alter the course of the case, an extreme emotional disturbance defense, often referred to as EED. Under New York law, this is not a claim that a defendant did not commit the act. Instead, it argues that the defendant acted while experiencing an overwhelming emotional or psychological disturbance. If successful, the consequences can be significant. A murder conviction could be reduced to manslaughter, and that difference can mean decades less time behind bars. But mounting such a defense comes with challenges. The defense must persuade jurors that the emotional disturbance was real and substantial. Mental health experts often become central witnesses. Medical evaluations can become critical evidence. And perhaps most importantly, the strategy can require the defendant to acknowledge involvement in the conduct itself. Legal experts watching the case noted that, given the strength of the prosecution's evidence, an EED defense may have represented one of the strongest available paths for the defense team, at least on paper. But then came a courtroom hearing that would spark a new mystery. In June 2026, discussions regarding a possible psychiatric defense took place behind closed doors. The proceedings were initially sealed. Defense attorneys argued that making those discussions public could affect jury selection. This was no ordinary criminal case. Media coverage was extensive. Public interest was intense. According to transcripts later released, defense attorney Karen Friedman Agnifilo expressed concern that publicly discussing a potential EED defense could prejudice both the state case and the federal proceedings. The concern was understandable. Once a psychiatric defense enters public discussion, it can shape public perception. Potential jurors may form opinions long before stepping into a courtroom. Judge Gregory Caro indicated he intended to unseal records related to the defense, and for a moment, it appeared that the legal strategy would soon become public knowledge. Then everything changed. June 2026. One day after indicating they would pursue an extreme emotional disturbance defense, Mangione's attorneys filed notice that they were withdrawing it. 24 hours. That's all it took. The strategy that had dominated legal discussion suddenly vanished from the case. Judge Caro responded by keeping the related records sealed. The public would not get a full look at the defense preparations, and almost immediately, speculation began. Former prosecutor Gary Galperin called the move stunning. His question was simple. What has happened since yesterday? It's a question that remains unanswered. Several possibilities emerged. Perhaps Mangione himself objected to the strategy. Perhaps a consulting expert reached conclusions unfavorable to the defense. Perhaps attorneys reassessed the risks and decided the approach could do more harm than good. Or perhaps something happened entirely outside public view. As of now, no official explanation has been publicly provided. And in the absence of answers, the mystery has only deepened. With the psychiatric defense withdrawn, attention now shifts to what comes next. Defense teams rarely abandon a major legal strategy without reason. The question is whether this move signals confidence in another defense or concern about the one that was abandoned. The prosecution, meanwhile, continues preparing for trial. They maintain that evidence connects Mangione to the shooting and supports their case. The defense continues to challenge aspects of that evidence, while maintaining Mangione's not guilty plea. For jurors eventually selected to hear the case, the focus will not be on speculation. It will be on evidence, witness testimony, expert analysis, and the legal standards that govern criminal trials. Until then, observers are left with a puzzle. A defense was announced, a defense withdrawn, and a crucial explanation that remains hidden behind sealed records. Every major criminal case has turning points, moments that change the direction of the story. For the prosecution of Luigi Mangione, the sudden abandonment of an extreme emotional disturbance defense may prove to be one of those moments. Was it a tactical adjustment, a legal necessity, or evidence of something happening behind the scenes that the public has yet to discover? The answers may emerge when the trial begins, or they may remain locked away in sealed court records. For now, one thing is certain. The mystery of the vanished defense has become a case file all its own, and the next chapter has yet to be written. What do you think happened behind closed doors? Why would a defense team announce a strategy and then abandon it just one day later? Share your theory in the comments below. If you enjoy deep dives into real criminal investigations, courtroom mysteries, and the hidden details behind headline-making cases, subscribe to Shadow Case Files and turn on notifications so you never miss an episode. Until next time, some truths are spoken in court, others remain buried in the shadows. Every case leaves a shadow, and every mystery deserves a voice. This is Shadow Case Files.